Hi, my name is Crystal Malik. I'm an immigration attorney with McCandlish Holton in Richmond, Virginia. For decades, our firm has represented employers, universities, and international students to file employment and family-based immigration processes. I've been asked to speak with you today about recruiting international students. Do not let fear of the visa process prevent you from hiring the best and brightest graduates available. U.S. law provides several ways for employers to hire foreign graduates of U.S. universities. Every year, the Immigration Service issues tens of thousands of new H-1B work visas. In addition, graduates of U.S. universities in F-1 status are eligible for 1 to 3 years of practical training, allowing them to be easily hired by U.S. employers. Work authorization options for international students in the United States are established by statute and regulation. When changes are made to these programs, it takes significant time. The last major immigration overhaul was more than 30 years ago, and with Congress essentially split, we don't expect major changes to these visa types in the near term. The two most common ways to hire foreign graduates are optional practical training and the H-1B visa. Optional practical training is referred to as OPT. OPT is for international students in F-1 status studying at a U.S. university. It allows 12 months of work authorization after graduation at each new degree level. For those holding STEM degrees, those degrees in science, technology, engineering, or math, there's an additional 24 months of OPT available. The student applies with help from the university for work authorization through the Immigration Service. When a company hires a student who has OPT, they can treat these employees just like other U.S. employees. This includes policies around pay, discipline, and termination. For STEM OPT, employers are required to sign off on a brief training plan. When you hire a student in OPT, there's no monetary or sponsorship requirement for the employer. The international graduate just fills out an I-9 form like any other employee. If you want to continue to employ the international graduate after OPT, the next step is typically the H-1B visa. This is an extremely popular work visa available to employees of any nationality who have a bachelor's degree or higher and will be working at a job that requires that degree. These visas last an initial 3 years, which can be extended to a total of 6 years. They can be extended even further under certain circumstances. For an H-1B visa, an employer must submit a petition to the Immigration Service and sponsor the employee. Employers at this stage are not required to prove that they cannot locate qualified U.S. workers. They must simply have a qualifying position and a qualifying employee and must be willing to sponsor that employee. They must also be willing to pay all fees associated with this filing. The government filing fees generally range between $2,000 to $3,400, depending on the size and status of the business. And legal fees vary widely between law firms, but generally are around $3,000. If your business has employees you want to sponsor for H-1B, it is important to understand that the H-1B system is run as a lottery. This is because there are far more applicants each year than there are H-1B visas available. Each year, the lottery is run in March for the coming year's quota of H-1B visas. This means that you'll need to keep a close eye on when your employee's OPT is starting and ending, and make sure to enter them in the lottery in March, any year when you'd like them to be able to continue working. If they're not selected the first year you enter them, you can enter them again the following year. Any visa won in March will be valid the coming October 1, the start of the government's fiscal year. It only costs $10 to enter each employee into the lottery, and once they're selected, it is the second step where the higher fees come into play. Please feel free to contact the university or your immigration attorney if you have any questions about this process. There are other work visas your employees might qualify for if they're not selected in the H-1B lottery, and if your business is a nonprofit, it's possible you might be exempt from the lottery system entirely. These are questions to be directed to a qualified immigration attorney who specializes in employment-based immigration. Thank you for your time today.